Grand jury secrecy is a well-established part of the American criminal justice system. Many condemn prosecutor Bob McCulloch for using this process in the Michael Brown Jr. case because it lacks transparency. Police officer Darren Wilson told the jurors his version of events, which led to his shooting of Michael Brown Jr. In fact, scores of witnesses gave testimony that the prosecutor said was vastly different from what many people believe happened. Officials have now released the transcripts from about 70 hours of testimony from 60 witnesses, and legal experts are taking a close look at that testimony. Monique Pressley is a former senior litigator in the Office of the Attorney General for the District of Columbia, and she joins us from Washington, D.C. And here in our New York studio, we have Gloria Browne-Marshall, who is the author of Race, Law, and American Society, 1607 to Present. She's an associate professor of constitutional law at John Jay College of Criminal Justice and a former civil rights attorney. Welcome, both of you ladies, to Arise America. I appreciate having you here.
Thank you, Debbie.
I want to start with you, Monique, if I can, and talk about these many witnesses that were called to go before this grand jury. First of all, what's your impression of the sheer volume of them? And then we're going to take a step forward to their conflicting testimonies.
Well, 60 is a colossal round number, right, Debbie? It's sort of amazing to me, just from 20 years in practice, to see that many different witnesses' versions of events being offered. There would literally be no way for a juror to not be confused just with the sheer volume. If you offer 5 who are closest in proximity, if you offer 10 who have the best earshot, it would make sense. But at the point that you've got 60 different versions of events, of course they're going to be conflicting. I mean, that's almost a self-fulfilling prophecy.
Yeah, and in this case, I would imagine some of those witnesses probably would not have been called had there been a trial. They wouldn't have been allowed to be called.
No, I'm certain that of the number of witnesses that you're looking at, a good prosecutor who's actually looking to win the case would have narrowed that list down significantly and would have vetted the witnesses thoroughly before even thinking about or considering putting them before a jury.
Gloria, let me turn to you. You paid particular attention to the testimony of Officer Darren Wilson before the grand jury, and I understand you told our producers that in many cases this reminded you of the George Zimmerman case. How so?
Well, in the testimony, we have this officer saying he got out of the car and then approached this person, Michael Brown. He's following him, in many cases, just like George Zimmerman. So you're following someone you fear. Why would you follow someone you fear? If you have this fear, why wouldn't you stay in your car, as was the George Zimmerman case? And then once again, we have this person, Darren Wilson, saying, and then he started charging toward me, and he ran, and I feared for my life. What is this place between charging toward me and fearing for my life? You didn't see a weapon before. Remember, he was struggling supposedly over his weapon inside the car. What was going to take your life? This is what we have to say, because for the grand jury, they're supposed to know there was reasonable belief of fear for their life. So the idea of what's reasonable under the circumstances, fear of getting beaten up, fear of being publicly humiliated, but why would he fear for his life?
Let me also ask you about that. We had our previous guest, Tariq Al-Shabazz, who felt very certain that Darren Wilson was coached and prepared for this testimony. Did you get the same impression by reading the transcripts?
He would have to be. There's no way in the world. For first and foremost, we have to remember, he had a very hefty legal fund that began the day after the shooting. And this legal fund, just like with George Zimmerman, was one in which we had people who were voluntarily giving him money so that he could be coached. He's going into the lion's den, so to speak, but he really isn't, because he's going in, giving up his Fifth Amendment rights, prohibition against self-incrimination, and he's sitting there, and it looks like he's giving a speech. A prepared speech, and he's not being cross-examined by the prosecutor, so he's able to say whatever he wants to say, and those poor 12 people are thinking of questions they are to ask him. How would they know just the right questions to ask this man?
I'm in no means a legal expert. That's why you two ladies are here, but it would seem to me, because I was able to read this transcript as well, that he was almost led through his testimony as opposed to answering challenging questions. Let me swing back out to you, Monique, if I can, and talk about some of these other witnesses. Oh my goodness, it would seem that we lost her. Okay, fine. Well, I got you right here, Gloria. So we'll just keep going. Let me talk about these witnesses with you, if I may. So many differing accounts. They differed. What it seemed to me on nuances. In some cases there were big variances, but in other cases they were really, really fine points. And it just seems so interesting that the only account that seemed to line up with the evidence was the police officer's account. That just seems so inconvenient.
Well, also think about McCulloch gives this press conference in which he sets out all the inconsistent statements. And my question was to myself, well, where were the consistent statements? If you're going to be this neutral magistrate, which is not his job, he's seeking an indictment, as was pointed out, which means he goes in with a purpose of trying to persuade these 12 people that they should indict. In this case, he decided he's going to be this neutral magistrate. He's going to give all the evidence out there, and they're supposed to ferret through it and find out what they think should be the rightful conclusion. For 12 lay people, it's impossible. He is supposed to present the evidence, the witnesses. He is supposed to present his case, and it only needs probable cause. So probable cause is a very low standard. It's not beyond a reasonable doubt. That's a complete trial. This is just, is there enough evidence for us to waste the money or spend the money, bring the witnesses, bring the system together to have a trial?
Gloria, let me ask you this. Was there a violation of trust in any way by releasing these transcripts immediately after making the announcement of the decision not to indict? This was a procedure done in secret, and it's designed that way for a reason. Was there some violation in trust here?
I think not only is there a violation in trust, I think there is groundwork for a lawsuit. A lawsuit should be brought, and I hope someone hears me, by one of those grand jurors for the violation of trust. A lawsuit should be brought by one of those witnesses for the violation of trust. Because if you can piecemeal that testimony together, I was standing on the corner at this particular time and I saw these particular things, then you know who that person is. And it's all supposed to be secret. I mean, that could put someone's life in danger. That could make their situation very uncomfortable. And that's why it's supposed to be a secret proceeding.
All right. Well, you know, it shocked a lot of people on a lot of different levels. Gloria Browne-Marshall, thank you so much. And we want to also say thank you to Monique Pressley, who joined us from Washington.
Thank
Appreciate
you.
it. And you're watching Arise America.